So for this section, I'd like to start with Judge Lisa Walsh, please.
Good morning. It is a great honor to be permitted to speak today, and I thank you for this invitation and His Holiness Pope Francis for his foresight. The United States prides itself on its founding principles and documents. One of the most revered principles in our development as a nation is the equal protection of laws, guaranteed by our Constitution. Critical to the ability to provide access to justice is the guarantee that all who come before the courts are treated the same without respect to race or gender. In the aftermath of our Civil War, the United States amended its Constitution to include the 13th, 14th, and 15th Amendments, which, among other provisions, abolished slavery, guaranteed due process of law, and prohibited states from denying anyone within a state's jurisdiction equal protection of law. Despite this amendment, the United States endured decades of racial discrimination until the 1954 bedrock decision in Brown versus Board of Education, which returned our application of the Equal Protection Clause back to its original roots, that all people in our country are guaranteed equal protection of law. This principle has been extended over the years to protection of other classes of people. Do United States judges treat all litigants, lawyers, parties, and jurors equally? Is justice truly blind? Every human is subject to bias, regardless of best intentions. In the last 10 years, different studies have been conducted to determine whether we have biases that we may not be consciously aware of that affect how we conduct ourselves in the court systems. These studies have concluded that even though judges and lawyers in the United States maintain core beliefs that in the equality of all people, that we carry implicit or unconscious biases which affect how we perceive and ultimately treat people. The subconscious mind uses three processes to make sense of millions of bits of information that we perceive. 1, sorting into categories. 2, creating associations between things. And 3, filling in gaps when we only receive partial information. These three processes working together allow us to create schemas, the frames through which our brains help us understand and navigate the world. The most impactful of the studies on how our schemas cause us to sort information in a way that disadvantages certain groups. The implicit association test, or IAT, created by researchers at Harvard University, is played like a video game, usually on a computer, to measure the reaction time to certain prompts. The tests are geared toward race, gender, and other categories to test reaction times when the prompts do not conform to stereotype norms. For example, the race IAT is designed to test preferences for European over African faces associated with concepts of good and bad. Gender IAT compares response time for associations of men with career and women with family with words or images associating men with family and women with career. So how does implicit bias affect the United States justice system? What difference does the prevalence of implicit bias have upon our systems? Implicit bias may affect how judges treat litigants, how legal employers make decisions on whom to employ and who should be promoted or assigned to positions of leadership or responsibility. Implicit bias in the selection of judges affects who is chosen to be a judge. The United States is comprised of both a federal justice system and a state court judicial system. In each of 50 states, which handle over 90% of all courtroom proceedings in the United States. The Brennan Center for Justice noted that white males are approximately 37.5% of the general population of the United States, and yet they comprise 66% of judges on state appellate benches. The American Constitution Society published a study called Gavel Gap, which concludes that roughly 75% of all state court trial judges are white men. Every other demographic is underrepresented on state court benches. Women in law firms are not promoted at the same rate as their male peers and leave in numbers that exceed their male peers. Turning to the effect of bias upon the success of women in the profession, in 2015, the American Bar Association Commission on Women in the Profession published the first Chairs study, which notes the connection between opportunities women receive in law firms measured against their prevalence at the top tiers of the profession. Today, only 17% of equity partners in big firms and 22% of general counsel in the Fortune 500 are women. This low percentage of equity partners persists despite women graduating at a rate of 50% of each law school class, and despite women earning their place at the top of their law school classes at roughly equal numbers as their male student counterparts. For example, a study of New York law schools reports women holding 54% of all leadership positions and 49% of editors-in-chief of their law reviews. The first chair study concluded that 68% of counsel in all federal civil cases were men, and 76% of lead counsel were men. Why is this important? The inability to gain success in one's chosen profession leads to one result: attrition. Obviously, women lawyers who leave suffer, but so do the law firms. Larger commercial law firms typically have general attrition rates at the associate level of between 15 to 25%. The New York City Bar Association also reported that attrition rates for minorities and women ran at rates of 50% or higher. And this results in a real cost for law firms. Losing an associate costs a law firm between $200,000 and $500,000 in salary, training, and benefits invested in that associate. Attrition may also affect the ability of law firms to retain clients. More than 170 corporations have penned an open letter to law firms to increase diversity of your lawyers or lose our business. Studies of disparities in criminal sentences and release of criminal defendants. Recent studies have shown that the United States judiciary has exhibited bias in imposing sentences and deciding bail issues. From 2016 to 2018, several studies have been done in my jurisdiction, and I sit in Florida, which measure racial disparities in sentencing and release of defendants. In 2016, a study concluded in studying less serious felony cases that black defendants receive almost twice as many days in jail than white defendants who are similarly situated. In my own county of Miami-Dade, 2 university sociologists in a comprehensive study found evidence that black defendants have a higher rate of arrest, incarceration prior to trial, and serve longer sentences. So what can judges do? Step 1 is defining what implicit bias is. Implicit bias refers to the automatic association of stereotypes or attitudes toward particular groups. Even though a person can have deeply held conscious beliefs that all people should be treated fairly, regardless of race, they still have implicit biases. Step 2 is training. The implicit association test referenced at the beginning of this paper has been shown to be a better predictor of human behavior than a person's stated intention or opinion. Research does show that biases can be overridden if an individual is made aware that they are reacting to unconscious bias. Strategies such as note-taking, creating checklists, developing objective criteria for decision-making, reducing distractions, and being mindful in decision-making, and requiring that a judge articulate reasons for making decisions have all been shown to work as bias interrupters. Judges also have the authority to make discretionary appointments of attorneys, which are prestigious and important. In 2016, the National Association for Women Judges authored a resolution encouraging judges to take diversity into account when making discretionary appointments of lawyers. This resolution has been adopted by many national voluntary bar associations. In sum, the promise of equal justice is not self-executing, even in a country which guarantees equality in our governing documents. The existence of unconscious bias is proven, developed subconsciously, and has affected the fairness of hiring procedures, criminal justice outcomes, and success in the legal profession. To address this problem, we have begun acknowledging it, educating ourselves, and seeking strategies to interrupt the mental processes that results in bias. The good news is that bias can be overcome. Thank you again very much for this opportunity.